Hi everyone, and welcome to the video lecture, Pre-Sentence Investigation Reports. In this lecture, we'll talk about what a pre-sentence investigation report is and how they affect the sentencing process. So what is a pre-sentence investigation report? A pre-sentence investigation report, or a PSIR, is a background report that's compiled by a probation officer, and it's intended for a judge to assist with sentencing. The use of probation officers to compile a PSIR was done because they were considered neutral parties to the defendant. Being involved in the correctional system, probation officers usually interact with offenders after they've been convicted. So by preparing the pre-sentence investigation report, they should not have any prior relationship or knowledge of the offender and are therefore considered neutral. As I'll discuss in this lecture, the pre-sentence investigation report has multiple uses, but the primary goal of a PSIR is to establish the least restrictive conditions that should be imposed on an offender during the sentencing phase. The information within the report is used by the judge to determine what specific restrictions are necessary given the defendant's educational, social background, criminal history, mental health issues, etc. Now there are two types of PSIRs. The first is the original PSIR, which is called a long form. The long form PSIR contains everything that a judge would need for sentencing. It should have a detailed discussion about the offender's history, including the educational, employment, social, residential, and medical history of the offender. It should also include information about the crime, including the offender's motivations, the offender's previous criminal history, and any additional factors that are believed to have influenced the crime. In this module, you can download a copy of the PSIR worksheet used by the United States District Court. You'll see that this form is quite extensive, 12 pages in length, with multiple narrative sections where probation officers can provide more detailed descriptions. Now, sometimes a complete long-form PSIR is not required. In these cases, a short-form PSIR can be completed instead. The short form, also called the selective PSIR, is intended to supplement the judge with necessary information, but it doesn't provide as extensive of a background. A short-form PSIR can be preferable for a variety of reasons, including sentencing for minor charges such as misdemeanors, or when an offender has had a long-form PSIR completed recently, so the short form is used as a supplement for some of the more recent information. Now, the disadvantage of the short form is that the fact that it doesn't contain all the information from the long form, so its use outside of the current sentencing process can be kind of limited. Short form PSIRs are very helpful for an agency, though, because a long form PSIR can be quite time intensive. As I'm sure you're aware by this point in the course, our criminal justice system is highly understaffed and overburdened in most areas. So a short form PSIR that requires less resources can help reduce the strain on the agency. Whether you use the long form or the short form PSIR, the PSIR will contain a probation officer recommendation. This is where the probation officer tells the judge, based on all of the assembled evidence, what the recommended sentence is. Probation officers at this point will either recommend community supervision or incarceration, and they base that on a variety of factors, including the defendant's rehabilitative potential, the danger to the community that the offender poses currently, and the anticipated public reaction of a community supervision sentence. Probation officers will also use the facts of the case to recommend a sentence length. This is based on legal requirements, in which many communities are based using a guideline system. So it imposes a sentencing range using things like a criminal history and the crime severity score. Probation officers must be knowledgeable about the sentencing guidelines in their state so they know what sentence is legally appropriate to recommend for each offender. The primary function of the PSIR is to assist with the sentencing decision, as I stated previously. However, that's not the only use of the PSIR within the criminal justice system. If an offender is placed on community supervision, either probation or parole, the pre-sentence investigation report is used to determine what type of supervision requirements should be imposed upon the offender. If the PSIR documents mental health or substance abuse issues, for example, this is a risk factor that the Community Supervision Office will attempt to address in the supervision plan of the offender. The PSIR can also be used if the offender is sent to a correctional facility. Our prison system in the United States is divided into security levels based on the risk for violence and other problematic behaviors in the offender. The Department of Corrections can use the PSIR information to determine what level of security is necessary for the prisoner. To make this decision, They can use things like the criminal history or attitudinal details noted in the report. Just like probation and parole individuals, the PSIR can also inform corrections about what type of treatment program should be utilized for the offender. Now, PSIR reports are also used for parole decisions. In these cases, the PSIR information may be a little bit older because it comes from before the offender was incarcerated, but the parole board examines the pre-offense behavior, the offense itself, and then the offender's behavior while incarcerated. So the PSIR can still be a really good source of information for the pre-crime and pre-incarceration information. Although not an official purpose of the PSIR, the contents within a PSI report can also be extremely useful for researchers looking into sentencing or parole decisions as well as supervision success. In my own research, I worked with the state parole agency's sex offender unit to evaluate a step-down program that was being tested on sex offender parolees. I used the PSIRs in each offender's file to collect basic demographics as well as important background information that would assist with my research questions. Another function of the PSIR that's become more important recently is the investigation into the financial stability of the offender. The Criminal Fines Improvement Act requires that judges consider multiple aspects of a defendant's financial situation before imposing a financial fine. First, judges must consider the regular income of the defendant, as well as their future earning potential and any financial resources they have access to. Judges must also consider the burden that would be placed on a defendant if a fine is part of that sentence. Now, this burden may be specific to the defendant, but it also may be something that influences dependence of the defendant. For example, if a defendant already has multiple child support payments that they have to do monthly, the judge must consider whether or not the imposition of a fine on that offender would negatively influence the defendant's ability to continue paying child support. And lastly, judges must also consider restitution compensation. Judges are not allowed to impose a fine that would impede the defendant's ability to make financial restitution to the victim of the crime. In this module, you can download a copy of the Net Worth Statement worksheet used by the United States District Court. The Net Worth Statement worksheet is designed to help probation officers collect the necessary financial information about an offender so a judge can impose a proper fine. If you look through the Net Worth Statement worksheet, you'll see that the probation officer will collect information about the current finances of the offender, including all of their bank accounts, their current balances, copies of their tax returns. But it'll also collect information about the financial resources of the offender by assessing things such as the amount of money owed to the offender and by the offender, the motor vehicles and the real estate owned by the offender and their market value, and then other assets the offender could liquidate for cash to pay the fines. So how does the probation officer go about actually creating a pre-sentence investigation report? The primary information gathering is done by interviewing the defendant. The probation officer will schedule an appointment with the defendant, and that's usually going to last about 1 to 2 hours. And this will allow the officer time to go through the defendant's history. In addition to gathering information from the defendant, the probation officer should also conduct investigations to verify information that's provided verbally. This information could come from official documents like criminal records, medical documentation, psychiatric evaluations, etc. It can also, probation officers should also seek out collateral interviews that can help confirm the defendant's background information. For example, probation officers will often interview parents, religious figures, teachers, employers, and other people that are important in the defendant's life in order to supplement the material provided from the defendant during the interview. When writing up a pre-sentence investigation report, it's important that the probation officer identify who provided the information and also inform the readers whether or not the information was confirmed. The following is an excerpt from a real PSIR that I gathered during my research with Nebraska State Parole. The defendant was asked to describe his relationship with his biological father, and he indicated, quote, "My dad didn't care for me, he had nothing to do with me," end quote. He additionally described his father as quiet, stupid, and unsanitary. He stated that his father was a dirty person and he never took a shower or bath. He also reported that his father was never home and was always out drinking. As you can see from this excerpt, the probation officer notes that this information was gathered from the interview with the defendant. The officer provides the direct quote from the interview and then summarizes other important information as well. Later in the same report, The officer documents how he reached out to the defendant's mother as well. The officer wrote, quote, "The writer of this report also interviewed the defendant's mother via telephone. The mother began by saying that the defendant was a handful when he was a child. She stated that he was out of the house for some length of time and in foster care because of her husband being an alcoholic. She stated at this point the defendant does not have contact with his father." Now, this information is clearly attributed to the defendant's mother, and it supports the information that was stated by the defendant previously. This type of confirmation can be particularly helpful when there are mitigating or aggravating circumstances that could impact the sentence. For example, if the father's alcoholism was relevant to the crime itself, then confirmation from multiple sources that this alcoholism existed could be important for the sentencing judge to take into account. In the criminal justice system, victims have the right to be informed about the offender's case. They have the right to participate in the case itself, and they have the right to be informed about changes in the offender's status and to provide information throughout the process of the offender's incarceration and release. Now, one of the ways that the victims can participate is through what's called a victim impact statement, which is a statement that the victim provides to the judge that describes the case from the victim's perspective. This impact statement can be orally given in court, but oftentimes it's written and it becomes part of the PSIR. So probation officers will regularly reach out to the victims to ask them to include a written statement as part of the pre-sentence investigation. This image on the slide is a section of the Texas Victim Impact Statement. As you can see, it requests information from the victim relating to things like emotional or psychological impact of the crime on the victim. The statement form also requests information about physical injuries and financial loss that can be used by the judge to assess restitution needs. Now, victim impact statements are optional, and not all victims choose to participate, but this is an option for those victims that want their voice to be heard during the sentencing process. In that example PSR that I quoted earlier, the officer was able to interview the victim as well, the defendant and the responding officer actually. And so he provided the offense summary from the viewpoint of all three perspectives. Now, victim impact statements can be provided from any victim regardless of age. Given the developmental differences, Texas has a different form for children so that they can complete their own victim impact statement for the judge. As you can see, children's statements rely more heavily on pictures and images so that even a young child can still verbalize how they were impacted by the crime, even without giving a written summary. In a victim impact statement, victims can discuss the crime and its effect on their lives, but they can also make statements about what type of sentence that they would like to see. Deceased or juvenile victims can be represented by a family member if they choose not to speak on their behalf or they can't speak on their behalf. The following slides contain some quotes from real PSIR victim statements that were collected during my research. So here is an example. This is an interview with an adult victim, and this victim is talking about a sentencing request. So it says, quote, "In regards to the sentencing, the victim stated that she wants to see the defendant have structure in his life and to get help. She feels that he needs long-term alcohol, drug, and psychological treatment. She stated that she does not want him to get out for a while, but could not come up with a time frame. She further stated that she doesn't want to go back to the life that she was living with him. The victim stated that after what he did to her, she doesn't want him to touch her. She stated at one time the defendant made a comment to her that, quote, 'If he couldn't have her, then no one can,' end quote. She reported she often thinks about that comment and it scares her due to his past mental history." So something like this is something that the judge can take into account. First of all, we have the fact that the defendant does not have this significant other to go back to. So we have a relationship void, so lacking the social support there. Secondly, we do have concerns about his comments to the victim about potential violence. If he can't have her, then nobody can. So the judge can take all of that into account when determining an appropriate sentence. This is from a letter that was written by the parent of a juvenile victim. So in this pre-sentence investigation report, the juvenile victim didn't provide her side directly, but the parent provided information about what the child was feeling and experiencing based on their observations. Quote, "I watched for 8 to 9 months her inability to log onto a computer to use the internet, even for a school project, because she was afraid that he or someone like him would be able to access her again. It was not until he was caught that she began to relax and move on. Now she is more likely to address the situation immediately with her parents, teachers, and her peers when she feels it's uncomfortable or threatening, and for that I am thankful. And this is from an interview, again with a juvenile victim, but this is a face-to-face interview. Quote, this officer asked the parents how things were going with the children. The father stated, I think victim 1 needs counseling, she needs therapy. Mother stated, victim 1 is just not the same. She used to be friendly, happy, go-lucky little girl. Now she's hostile. She's constantly fighting with her brothers and sisters. She's not doing well in school. She used to be very popular, and now she doesn't appear to even care. So again, all of these things are helping the judge determine what kind of trauma that the crime had on the victim and what's an appropriate restitution. Okay, so now that you know what goes into a PSIR, I want to switch gears a little bit to talk about how the pre-sentence investigation report influences the sentencing decision. And we'll also discuss some criticisms of the PSI report as well. There's been a lot of research on sentencing recommendations and final sentences, and most researchers find fairly high concurrence between the two. Norman and Waldman in 2000 examined probation sentence recommendations in 2 Utah counties, and they found that in 92% of the cases, the sentencing recommendation in the pre-sentence investigation report was followed by the judge. In that same study, they interviewed over 200 courtroom actors, including judges, prosecuting attorneys, and defense attorneys, and they found that 80% of the sample agreed with the statement that the sentencing recommendations within the PSI usually reflect the appropriate sentence given the crime and the defendant's history. A more recent example by Lefkar and Sample in 2011 found that the final sentence followed the sentencing recommendations exactly in 79% of the cases examined. Both researchers noticed that in those cases where the judges deviated from the recommended sentences, these were felony cases. So both researchers found that in less serious cases, the judge's sentence basically always followed the probation officer's recommendation. Only in those more serious cases were judges going to deviate either a harsher sentence or a less harsh sentence than was recommended. One of the concerns with this sentencing similarity is officer subjectivity and the inclusion of potential bias in the PSIR. Remember that these sentencing documents are created by a single officer, and while some may be completed using a variety of sources, others will rely heavily or even solely on an interview with a defendant. Probation officers may form impressions of the defendant that influence the final presentation of the report and the sentencing recommendations contained within. Whether or not those impressions are factually based is often difficult to determine. To illustrate this problem, I want to discuss one of the recent court cases that you may have heard about. It's called the Stanford rape case. In this case, the defendant Brock Turner was charged with rape after being caught having sex with an unconscious victim on Stanford's campus. He'd been drinking with the victim at an on-campus party previously, and during his trial, he argued that his own intoxication and the college party lifestyle was the reason for his behavior against the victim. Now, Turner was convicted of 3 counts of rape by a jury, after which his case was sent to the probation department to create a pre-sentence investigation report. That PSIR, which I've provided you in the module, includes a sentencing recommendation for a short jail sentence followed by a probationary sentence of 3 years. In the PSIR, the probation officer wrote, quote, in determining an appropriate recommendation, this officer considered myriad factors, including the impact of the crime on the victim and the safety of the community. Other factors include the defendant's lack of a criminal history, his youthful age, and his expressed remorse and empathy towards the victim. During the pre-sentence interview, the defendant demonstrated a comprehension that the victim in her state was unable to make an informed decision, and in that moment, he had a moral responsibility to act in her best interest, which he failed to do so. This is another quote from the defendant interview that supports the probation officer's reasoning for the reduced sentence. During the pre-sentence interview, the defendant expressed sincere remorse and empathy for the victim. He stated, quote, having imposed suffering on someone else and causing someone else's pain, I can barely live with myself. I can't get out of my bed in the morning. I think about it every second of every day. The victim having to go through the criminal justice system because of my actions, it's just unforgivable. Now, as you can see, these quotes contain subjective information. The probation officer in the PSIR repeatedly discusses Brock Turner's remorse, but the presence of this remorse is based on the officer's subjective interpretation of Turner's verbal and nonverbal body language during the interview. Due to the subjective nature of the statements, it's possible that another probation officer conducting the same interview would document Turner's remorse as faked or insincere, and nobody really knows the truth, so we don't know what Turner was like during that interview. Near the end of the evaluation for Brock Turner, the probation officer states the following, quote, "This officer weighed the fact that this 20-year-old offender is now a lifetime sex registrant. His future prospects will likely be highly impacted as a result of his conviction, and he surrendered a hard-earned swimming scholarship. Perhaps just as importantly, but sometimes overlooked, are the victim's wishes as to the potential outcome," end quote. Now, based on the evaluation, as I said, the probation officer recommended a moderate county jail sentence followed by formal probation. And Brock Turner was officially sentenced to 6 months in jail followed by 3 years probation, which followed the probation officer's recommendation exactly. While you may disagree or agree with Turner's sentence, the issue here is the subjective nature of the information that's contained within the PSIR. Many people are calling the report biased, noting that the referral to his swimming scholarship was not relevant to the rape conviction. Was Brock Turner's ethnicity and wealth influential in the PSIR process? We don't know for sure either way, but the fact remains that this recommendation relied on subjective opinions by the probation officer when determining the sentencing recommendation. And this practice of using subjective information during this decision process is not unusual, but rather a pretty standard part of the probation officer's evaluation. Many people criticize that the practice of including this type of subjective information could produce bias in the final report and ultimately then bias into the sentencing process itself. There are a few other criticisms about the PSIRs that I want to discuss here. The first is how inaccuracies in the PSI document are handled. We discussed previously how time limitations may impact how well the PSIR is validated with additional sources. This leads to the increased possibility of errors in the report. I have a quote here from the Michigan's Manual for District Court Probation Officers, which states that, quote, "Because of high caseloads and time constraints, many courts have designed abbreviated pre-sentence investigation reports to capture the most basic and pertinent information needed by the judge. The judge should be made fully aware of the limitations of this type of report. A thorough investigation probably has not been conducted, and not all information has been verified. There may be some records or reports that have not been obtained." Now, if the PSIR does contain errors, it's really difficult for the defendant to get the PSIR corrected. The federal courts have ruled that in order to discard a sentence based on faulty PSI report information, the defendant must show that the error was, quote, harmful. This means that it's up to the defendant to find the error, identify how this error caused a more severe sentence, the harm, and then show the court that fixing the error would result in a lesser sentence. This can be easy in some cases. For example, if there's an error with the defendant's criminal history record, this can impact the sentencing guideline ranges, so the defendant can show the harm a lot more easily. But often errors are more minor, and they may be more difficult to prove harmful. How do you show that a judge that a discussion of your social history, while inaccurate, was also harmful to you during the sentencing process? Another problem with inaccuracies in the report is that they're not always fixed in the form itself. While the lawyer may address the problems with the sentencing judge, the same inaccurate PSIR report will be used further in the criminal justice process by the corrections department, the parole board, as well as researchers without ever being revised necessarily. So a lot of times that inaccurate PSIR report is the only permanent record because the verbal information given to the judge at the time of sentencing isn't captured on anything other than the sentencing transcript. Another criticism of PSI reports is that there's no limitation on information that can be included. Hearsay statements, or when someone testifies about something that they overheard from another person, are not admissible at trial because they're not reliable, but they can be included within a PSIR. Physical evidence that was excluded from trial because it was captured inappropriately can also be discussed within a PSIR. Also, there are no limitations on the criminal history patterns like there are in trial testimonies. Juvenile records, even those that are sealed, can usually be disclosed in a PSIR. Since none of this evidence would be admissible to determine guilt, many feel that this type of evidence should not be admissible when determining sentence type and length as well. Finally, one of the last criticisms I want to discuss is the question of representation during pre-sentence investigation interviews. The Supreme Court has ruled that Miranda rights do not apply to PSI investigations. Therefore, the defendant does not have the right to remain silent, and a lawyer is not required to be present. Currently, only one state in the United States requires defendants to have a lawyer present during the pre-sentence investigation report. So there is a concern that what if the defendant is saying things that they wouldn't have said if they had a lawyer advising them of their legal rights next to them. All right, well, that concludes the pre-sentence investigation report video lecture. Thanks for watching.